Decisions here, and tonight I'm actually going to be brief, but I'm going to make sure first that you guys can hear me.
I let off two shots, I hit
Well, that ain't it.
him in this shit not fun.
Sure first that you guys can hear me. All right.
I let off two shots, I hit.
Well, that ain't it. Well, we know it works now. All righty. So now we know that's working. Let's go. The reason why I want to do this video here tonight was simply because I have a couple cases that I'm working on, but one popped up and it seemed like it was this week's new motto. And the thing was being forced into a plea. Now, I wish it was an isolated incident, but like I said, this seems to be the thing. Because let me give you a couple breakdowns. Each of these people have different situations, different things going on. But the one common denominator in every one of the cases is the simple fact that their attorney is either attempting to force them to plea, or in one case, I have a judge forcing a plea on a defendant without a conviction. None of these people have gone to trial. None of these people have actually entered a plea, which is the most outrageous thing I've ever seen. But I wanted to get into that real quick tonight, which is not going to be real quick. So I hope you get your drinks. I actually have Arizona tonight. I don't have my yak. Tonight ain't a yak night, but it's also young. So I might come back tonight, depending on how you guys do with this. And don't forget, Super Chat is open. Always remember to support the channel so we can keep going and keep growing. And as you can see, we are getting better equipment, having better outlooks. I might start the fire too, so never know. It's actually pretty decent out here, other than it's raining. So, it's one of our 20 days this year. Anyway, how to weaponize Boykin v. Alabama to stop a court from steamrolling a guilty plea when when counsel is inactive. Evidence is unchallenged and pressure is on. And the reason why I worded it that way is because it is a steamroll effect. When your own counsel, whether hired or as a public defender, they're telling you your only option, not just the option or your best option, your only option is to plead guilty, even if you aren't guilty, and they are not challenging state's evidence. And again, this is one, actually two, are from people that have paid attorneys. One is from an attorney that was provided by the state. Each of them have stated they will not challenge state's evidence and have not. And you know what? Let's just get into it. Because this is one of the things that the judge just said literally yesterday. And I generally don't put people's name out. But down in Harris County, Betty Collins. Yes, I said your name, so look at it. Go look it up because, yeah, it's getting ready to be fun with Miss Collins. Or excuse me, Judge Collins. You don't take a deal. You waive constitutional rights. And if the system is pushing you to a guilty plea when your lawyer hasn't filed a meaningful motion in months or even years, then they are really asking you to do is sign away your rights without informed consent. The reason, again, why that first sentence is in there is because I watched all three of these lawyers that are forced. Now, keep in mind, they're defense attorneys. They're forcing these pleas because they have not filed a motion on behalf of their client, paid and public defenders. because I always revert back to this, the Tommy Sotomayor question. If you have not listened to that episode of my podcast, go back and listen to it, because he asked a very clean, honest question. And the whole thing was he wanted an answer. And I keep bringing up these things. People with a bar card are not on your team. And this is one of those, well, hell, this is 3 examples of that. Because again, different states, different time zones, different courtrooms, different charges, all of them are doing the exact same thing. I don't tell you a lot of this just to be talking. I'm telling you this to protect yourself. Because literally, I have one case where the lawyer has not filed a document on behalf of his client who's paid him 5 figures since August of 2024. And that's as of today. August 24, 2024 has not filed anything on behalf of his client. But he's telling his client, you need to go to trial, but they're going to give you 15 years, so I'm trying to get you 9. You haven't even challenged the evidence? And the thing is, when you're looking at these things, it's imperative that not only you understand what's going on in your case so you can help with your defense, because they are assisting you. That's why it's ineffective assistance of counsel. They are assisting you. You are the master of your case. McCoy v. Louisiana. You direct your case, and if you don't, this is going to be the result 9 out of 10 times, unless you're spending $50,000 or more. So understand this, because hell, I even had one that was $30,000. He did the same shit until I was hired on, and I had permission to have the contact with him. Muted. Is it back on? What's going on? Did it? Oh, there we go. There we go. All right. Now, let's be direct. A guilty plea is not just words. It's the end of your case. It's the moment you surrender the right to trial, the right to confront, your right to confront witnesses against you, the privilege against self-incrimination, the core protections that the Constitution treats like oxygen. And the Supreme Court told courts exactly what they must do before they accept that surrender. That is the law that they must follow. That case is Boykin v. Alabama. That is the law. The principle is simple and brutal. A guilty plea must be voluntary and intelligent. Not I'm tired. Not I tried. Not I don't want to upset the prosecutor. I'm scared. I've actually had a lawyer say that the other side is very formidable. I don't know if I should file that motion. That's what he actually put on paper after he took a payment. Not my lawyer says I have no chance. Not the judge implying my bond might be pulled if I don't plead, which again, I put that in there because Judge Collins said that yesterday. Just let that be known. I said it, Harris County Judge Collins, Harris County, Texas, down in Houston. Yes, I'm saying her name. Now, voluntary means no coercion, and a judge telling you, if you don't plead, I'm going to pull your bond. That's not unbiased. This is the one thing most people don't catch. The judge must be a neutral judge and not helping one side. And to sell someone that has not been convicted of a crime, that has not gone to trial, if you do not plead guilty, I'm going to revoke your bond, that is bias. That is wrong. That is not what the Constitution upholds. That is against the law. And again, I said this because I witnessed it yesterday. Now, and I appreciate everybody that's coming here that was looking for Frankenstein. I understand that. I'm going to finish Frankenstein, just not right now and probably not tonight. But I felt this one was more important at the time because I have a couple other things that I got swimming around. But I want to make sure this gets there. So hold on, let me take a little sip of the yak. All right. So voluntary means no coercion. Intelligent means you understand what you're giving up and what you're walking into. And here's the best part most people miss. Boykin is not just about what you feel. It's about what the record shows. The court can't just assume your plea is valid. The court must make it clear on the record that you're knowingly and voluntarily waiving rights. That's why Boykin is a courtroom weapon. It demands for a clean record and a clean process. Now, I'm going to give you something that I normally don't do. This is why when you are first charged, if you're going to hire someone, it is important. It's of the greatest importance to set forth the boundaries in which your lawyer can operate. Always understand that it is important you set forth the boundaries. They are an employee because when you pay someone, whether they're a contractor or not, you are their employer. So you treat them as employees. You don't just accept everything that they give you. You make an intelligent decision, and especially in this case because it's your life. Understand that it is your life that's on the line because they're not going to do it. I actually had a young lady tell me today that I almost laughed at. And the thing was, she said, I don't want to upset my lawyer. I asked her, I told her, I said, your anger must be a little bit misplaced about wanting to upset someone. Because if he messes up, is he going to pay your fine? Or is he going to do the time that he messes up on? Or are you doing it? Because if you're worrying about upsetting someone that you're paying, you're in the wrong position. Your mindset is done because you are the master of your own fate. You choose how this battle goes. Because see, now add this reality. The defendant has told the court clearly that counsel has not filed motions since 2025, has not challenged evidence, and the system is pushing the defendant toward a plea anyway. If that's true, then the choice to plead starts looking less like a decision and more like a corner. And a plea made in a corner, under pressure, without litigation, without meaningful challenge to evidence, raises the exact constitutional problem Boykin exists to prevent. Understand that. Boykin v. Alabama is put together to prevent this type of sloppy work. So today I'm going to give you a trial level framework, not theory, a practical blueprint on how to spot a forced plea environment, how to build a Boykin record that stops the plea train, what to say in court, clean, short, aggressive, and how to pivot, the continuance, motion practice, substitution of counsel, and even pro se control. Because if the court accepts a plea that isn't voluntary and intelligent, the plea is defective. And if counsel's inactivity is part of the pressure machine, the defense must force the court, force the court to confront that reality before the defendant is locked into a conviction. And today, this episode is going to be part of your playbook ritual to make them do the right thing, not do it at all. All right. When you're talking about Boykin in this context, Boykin is about the validity of the waiver. Courts must show not pressure waiver from silence. So when you have the defense attorney who's not challenging evidence, and you have the prosecutor that's going along with this, and then you have the judge who's making threats to you, that's a violation. That is illegal. That is something that you can actually do what's necessary to get it thrown out. Because a plea is a waiver of trial rights. The record must show the waiver is knowing and voluntary. Two things. Because you remember, I keep telling you, the biggest words in law are if, and or. If and or. Because they are action words. Understand this. You might want to do the Ebonics. Does not change what's said and what's done, nor how it's applied. Because the teach of beats, voluntary, no threats, no implied pressure, no false promises, and no coercive timing. Intelligence, understanding the rights that are being waived. And I think somebody just put it up here just a few minutes ago. The true nature of the charges. The direct consequences of your plea. And here's another one. Enough understanding to the choice that you're making. Right? And you keep it record focused. If the record is thin, you attack the plea. Because I asked the question today. Young man stated that they told him that there was a nexus. Say, okay, you've identified the problem. What are you going to do to defend it? Because that is literally the job of a defense attorney. When a defense attorney says they're not going to, they identified the problem and they choose not to do anything about it, they're not working for you. They are not doing their jobs. You have defense attorneys who are not defending. They're not on your side. How do you hold them accountable? That's, again, why you lay out a foundation, because you got to make sure that you stay in control in all aspects of it, especially if you're the boss and you're making payments. If you're paying their salary, they work with you. They work for you. They're assistants. So, Boykin is not vibes. Boykin is the record and transcripts. Now, here's a key one, because this is another one that's in a separate case. Forced pleas don't always look like a judge yelling. They look like a system squeezing time. This is one of those where you're constantly going to court. You're going to do this. You have to come back every 30 days because the system is looking to drain you. Or they'll tell you, plead today or we're going to revoke your bond. We're going to raise your bail. We're going to set it for trial tomorrow. That's pressure. Excuse me. But here's the biggest problem with that. Because the counsel is unprepared because haven't filed any motions, did not file any suppression work, and no discovery fights. And because I go back to this, because anybody that's watched me for a while, one of the things I spoke about, because even I've had 2 defense attorneys on my show, and one of the things that they pointed out was both of them, they came to me when they got in trouble. Both of them stated they had never filed a detailed discovery until I gave it to them. Let that sink in. They've been doing this, I think one at the time was 5 years, the other one was 7 years. They had not, this came out of their mouth, not mine. They had not filed a detailed discovery in 7 years. Had not filed a detailed discovery in 5 years. Why is that? They're defense attorneys. Why would they not file an actual detailed discovery? That's because they didn't know what it was, because they were just in the system. They wasn't even actually part of it. I'm gonna leave that out there because somebody's gonna figure it out. But understand that being unprepared is the worst thing you can have, because even whenever I was doing this, one of the things I did whenever I was playing basketball, I always watched tape. That was preparing me for the next game. Because I want to find little nuances. I want to find little things that most people aren't paying attention to. And here's the greatest stage of this. It's understanding when there is no challenge to evidence, your attorney, as a defense attorney, is allowing hearsay. Your attorney is allowing hearsay against you because he's not challenging evidence. We'll see what happens at trial. That's not a strategy. That's hope. And unless he's Obama, that's not working. Cause I think hope is the only, Obama's the only one that won on hope. You have to go because you're prepared to win. Because when you're not prepared to win, you are prepared to lose. I'm going to say that one more time. If you're not prepared to win, you are preparing to lose. And then the plea becomes a rubber stamp. Because again, you're just part of the system now. Because pressure plus no defense equals a fake choice. Because if counsel hasn't litigated, in this example, since 2024, the defendant cannot intelligently assess risk because the record has not been tested. How can we come up with a strategy if there's been no plan of attack? We haven't went at anything. We haven't tested the warrants. We haven't tested IDs. We haven't even questioned witnesses. We don't even have full discovery. But we going to trial? How is that possible? But if I go to trial, I'm gonna get 15 years. Even though I'm paying you to do a job that you just flat out not going to do. Always understand that. Here's the best part. The defendant isn't obligated to plead guilty to cover the counsel's inactivity. Because you're the one going to jail, not them. You're the one paying the fine, not them. So when your lawyer hasn't filed motions, he hasn't forced disclosure, he hasn't challenged admissibility, you haven't boxed the state into any story. You are just riding blind. And the key part to Boykin v. Alabama, the intelligence part of it. The intelligent plea requires a meaningful ability to evaluate options. If you have no clue what those options are, what are you evaluating? And most people will miss that because that's when I hear, will they just do anything? That's because you don't know how to stop it. Because you're just accepting it. Because you don't want to challenge it. You haven't taken control of it. And this is part of what we talk about as far as the accountability. When you have something and you allow it to happen, because that's what it is. Because whenever you go to jail due to the inactivities of counsel, you allowed the ineffective assistance. Because that's literally the charge. Ineffective assistance. And the second, because here, I want you to understand something. They want you to be responsible for that. But they don't want you to take over your own case. Why? Because that's when you're the most powerful. Because they are required to then assist you every step of the way. In every aspect of the legal system, everyone that's there is working for you because each one of those people are servants. They're trustees to the public. And guess who you are? You're the public, which means they must work for your benefit, which is why they don't want you going pro se. I'm gonna let that one slide because I'm gonna let you catch that one later. But I want you to understand that. Because even in the idea of even a practical line, whenever you're going in a pro se stance, it's my honor. I cannot intelligently waive trial rights when the counsel has not litigated, has not challenged evidence, and I'm being pressured to plea. That's almost a bar. My honor, I can't intelligently waive trial rights when the counsel has not litigated, has not challenged the evidence, and I'm being pressured to plea. And this is one of the most things that most people miss. Because most defendants lose because they complain off the record. Because remember, I'm going to throw something in there because I say this constantly. Any waiver of rights must be done in writing. So any exercising of right must also be in writing. Understand that. If you're going to waive it, it must be known and intelligent. Any waiver must be known and intelligent. So if you're enforcing a right, put it in writing. Because everybody talk about, well, they wouldn't put it on the record. That's because you didn't do something correctly. 90% of the times, that's what it is. There was something missed or something that was allowed. And here's the things. One of the things I used in the RICO trial, I used the words forged, biased. Why? Because that's what was happening. And then to correct their behavior, in a sense, we won, I want to say we won 3 or 4 out of the next 5 objections. 3 of them we shouldn't have, we won 4 of the next 5. 3 of them we had no business winning. We were just objecting to be objecting. And we won the objection. And I was like, why? And that's the overcorrection of the system. But it's also understanding that's a tool that we had. And once we used those words, it showed the power of the words. Now, when you use them and you say them out loud, I am under pressure. Counsel has not filed. Counsel has not challenged. I am entering a plea that's not voluntary or intelligent. These things matter. And don't let the court rush you past your objections. You are the controlling asset to this. Now, I appreciate you guys. I'm going to come back because I got a couple things I need to do. But when I come back, I hope you're ready. And let's keep going. Let's keep growing.